Assemblyman Jeffrey Dinowitz. I chair the Consumer Affairs and Protection Committee in the Assembly, and this hearing is sponsored both by our committee and the Judiciary Committee, which is chaired by Assembly Member Helene Weinstein. We're also joined by Assemblyman Steck, who came all the way from Albany to join us. And I'll just make a very brief opening statement, and so will my colleague. First, I'd like to welcome everybody here for this hearing on arbitration. Our Committee on Consumer Affairs and Protection makes it a priority to ensure that New Yorkers are able to make informed decisions with regard to signing contracts. And the trend of sending disputes to mandatory arbitration proceedings rather than letting them play out in the court system, as we all know, is growing in the United States. And the odds are that at some point you have signed a contract which contains an arbitration clause. And in many cases, those arbitration clauses are mandatory and non-negotiable. However, an arbitration proceeding may or may not be. It's not necessarily the fairest option for a consumer to dispute a claim. So therefore, one of the goals of this hearing is to find out the impact that arbitration proceedings have had on consumers and businesses in New York, and in order to make sure that the average consumer is able to have a fair representation if they've become part of a legal dispute. So we've come together today to hear testimony from a number of groups who can shed light on this topic. For the sake of time, you don't necessarily have to read all of your testimony word for word because it's all part of the record, and we certainly will be reading it. So if you want to just speak in a concise way, that would be better than just simply reading. And now I'd like to turn it over to Assemblywoman Weinstein.
Thank you. I'm very happy to be here at this joint hearing. As was said, the hearing seeks to explore a number of significant issues in the law, including how legal disputes between parties to an agreement should be adjudicated. Should they be adjudicated in our court system, or should they be required to be adjudicated in an arbitration forum? Should such out-of-court adjudications be voluntary or mandatory? For cases proceeding via arbitration, how can we ensure procedural safeguards and fundamental fairness? And do mandatory arbitration clauses in consumer and employment matters allow for mutual assent sufficient to form a contract? And if not, is there something we can do legislatively without being preempted? In the past, as I think people in the room know, this has not been as big an issue. Most such disputes were, in fact, resolved in court, but now, given fairly recent holdings from the U.S. Supreme Court, which were in turn followed by New York's own courts, we are seeing the beginning of what may well be a sea change in the law as more and more cases head into arbitration, often against the wishes of parties involved. So the hearing will address the question of whether this trend towards mandatory arbitration of disputes between parties to an agreement is in the interests of the people of the state of New York, especially, and that's why we have Consumer Affairs chairing this committee, this hearing with us, including consumers and employees. And we invited you, the experts in the subject, who can give testimony from perspectives concerning these issues, and we look forward to learning more from those of you testifying and whether a legislative solution to some of the issues that will be raised today is constitutionally appropriate and or warranted. And also we've been joined by a member of both the Consumer and Judiciary Committees, Assemblywoman Rebecca Seawright. Jeff?
Okay, our first witness is George Carpinello, Chair of the Civil Practice Advisory Committee, OCA, New York State Unified Court System. Good morning.
Thank you.
We would ask our witnesses to swear to tell the truth. So if you would raise your hand, do you swear that your testimony will be the truth?
I so swear.
Okay. Go ahead.
Thank you. Thank you for inviting me today. As the Assemblyman said, I'm chair of the Advisory Committee on Civil Practice for the Office of Court Administration, but I want to make it clear that my comments today are those of myself and not those of the committee, or certainly not of OCA or the Chief Judge or the Chief Administrative Judge. Our committee makes recommendations to the Chief Judge and the Chief Administrative Judge on changes, proposed changes to civil practice in New York. I can say on behalf of the committee that the committee is very concerned about the trend that both of you have touched upon, which we think is probably the biggest threat to due process in the civil field really in our lifetime. It's a massive change, mandatory change, depriving large groups of individuals of not just their right to jury trial, but their right even to get into the courthouse door. And the committee is very concerned about that, and we look forward to working with both houses of the legislature to devise ways to restore at least a modicum of due process rights to New Yorkers. Taking your advice, I will not read my full statement, but I do want to touch upon a few points. First, I think it's very clear that when the Federal Arbitration Act was passed in 1925, Congress did not intend to have the wholesale deprivation of due process that we have today. The statute was passed to overcome judicial reluctance to enforce arbitration agreements among sophisticated businesses who voluntarily decided to take their disputes outside of the court system to a private system of adjudication. There's even a question as to whether it was ever intended to apply to state courts at all. And I agree with Justice O'Connor, who said long ago that this was really not intended for state courts, and Justice Thomas, who adheres to that position, that this was not intended to interfere with the jurisdiction of state courts. Because if it did, and it does, it's a massive intrusion by the federal government into the states, going to the very heart of the state's jurisdiction, that is the right and the power to govern who gets into their own courthouses. And that's what's happened over the last 15 years. Let's be clear what the goal is of those businesses that impose mandatory arbitration clauses on consumers. The goal is not swift or more efficient justice. The goal is no justice. As was quoted in the New York Times article by one of the lawyers who devised this plan, the beauty is that the cases just disappear. Why do they disappear? They disappear because, for most consumer cases, the amount at issue is far too small to justify hiring an attorney and seeking redress in front of an arbitration panel. It's simply not worth the effort. Clearly, the major businesses that have adopted this mandatory arbitration, their goal is to send an arrow through the heart of class actions. Now, there have been a lot of class action abuses over the years. I think they've been addressed in many, many ways. Certainly in the securities areas, they've been strictly curtailed, and the judges themselves have attempted to impose certain limits on class actions and on the exorbitant fees that class action attorneys sometimes get in cases. We've all heard about the cases where the class gets a coupon for worth $1.50 at Starbucks and the lawyers get $3 million in fees. Those cases are beginning to disappear, but nonetheless, the class action vehicle serves a very important purpose, and that is it redresses the rights of consumers where the amount at issue is not enough for any individual consumer to seek justice. That's why the class actions were developed. That's why businesses originally asked for class actions, because they felt they were inundated by a variety of cases, a slew of cases around the country. Let's get them consolidated into one case. So let's be clear. The goal in putting mandatory arbitration clauses is not to get swifter justice. The goal is to avoid justice entirely. Arbitration is a private, secret, and closed process. We value our open courts in this society. My committee in particular has worked very hard to develop rules for the unsealing of court records. Rule 216, Uniform Rule 216.1 was developed by my committee at the request of the Chief Judge, and we're very proud of that rule because that has been a rule which has enforced the unsealing of records in the courts throughout the state of New York. And if you read the opinions of the courts are very strict about sealing either the courthouse or the court records because justice should be open. Why? Because the most important guarantee of due process, the most important guarantee against corruption is to have an open system subject to scrutiny by the public. Arbitration is the exact opposite. So briefly, what can we do given the Supreme Court decisions that we all know about? First, I think it's important to make this issue the consumer issue of 2016. It has not gotten the attention it really deserves. And I think it's important for each of you and each of us to constantly talk about this issue. In terms of concrete legislation, we think that New York should adopt a statute that makes it clear at the very least, that any party that imposes arbitration clauses on consumers be bound by arbitration itself. The irony is, and this was again pointed out by the excellent New York Times series, is that creditors, in particular purchasers of consumer debt, have flooded the courts with actions to collect on that debt, but when the consumers turn around and try to sue because of bad practices by the creditors, they are met with an arbitration clause. Several state court decisions outside of New York have said the consumers are still bound by arbitration. We should end that process. If a creditor or any other entity wants an arbitration clause, they're stuck with arbitration. They don't get access to the court system. Second, we should ensure that in any consumer arbitration, there should be neutral and impartial panels. One of the problems with arbitration is that the industry representatives are in front of the arbitrators all the time. The consumers may be in front of an arbitrator once in a lifetime. Who are the arbitrators going to favor? If they want to get picked time and time again, they're not going to displease the corporate representatives. Even if it's your very honest arbitrator, inevitably there's going to be pressure not to piss them off, so to speak. Excuse my language, but that's effectively what they would be concerned about. So we should have the Attorney General adopt rules and regulations and even set up an impartial panel for all consumer arbitrations to ensure that we have an impartial group of arbitrators that arbitrate across a wide variety of industries. Third, contracts should be clear and unequivocal. If someone's going to impose mandatory arbitration, the language should be clearly labeled in bold type and should be explained in layperson's terms so that everyone can understand the significance of the arbitration. Fourth, the legislature should consider procedural rules that require arbitrators to provide a complete explanation of the basis for their findings, including a delineation of findings of fact and conclusions of law, and consider making consumer arbitration at least subject to full judicial review. As we know, arbitrators generally do not have to give a reason for their decisions, and there's very limited review of arbitration decisions. And that's really for good reason. In the context of voluntary arbitration, the parties have chosen a process different than the court process. They don't want to be in court. But for consumers who have no choice, they should be entitled to at least the elements of due process to find out why they won or lost and to have a full review. Finally, the legislature should consider banning any contracts that would determine the rights and duties of the parties with regard to particular relationships. We know that any state statute that prohibits arbitration or prohibits any waiver of rights to go to court have been struck down by the Supreme Court as being preempted by the FAA. And this proposal may also, but you should consider the possibility of, in certain areas, for example, in the field of healthcare providers, saying that there should be no contract determining the rights and the duties between the provider of care and the patient. That relationship should be determined by state statute, regulations, and the common law, and that there's no place for a negotiation or a limitation of rights in any way when someone's entering a nursing home or a hospital. The Friedman case, the First Department recently held that it was okay for a woman suffering from dementia entering a nursing home where her son signed 14 forms when she was placing her in the nursing home, one of which was a mandatory arbitration clause. And the court said that's not unconscionable. And the public health law of New York, which says you cannot waive your rights, is entirely preempted by the FAA. So you ought to consider that as a possibility, basically saying we know that any statute focused on arbitration is going to be struck down, but you should consider the possibility of saying it's not appropriate at all for a hospital or a nursing home or a doctor to try to limit their rights in any way by a non-negotiated contract with the patient who really has no choice. You're entering an emergency room, you're suffering from a heart attack. By the way, you have to sign this form before we treat you. That's not an arm's length negotiation. That's an adhesion contract. Thank you.
Thank you. I'm sure you don't have data on this, but do you have an opinion? How many people actually have any idea that they signed the contract, which includes arbitration, in your opinion?
Well, mostly nobody. you know, you run across this when if you have a credit card. I'm sure you probably have a credit card. I'm guarantee you there's an arbitration clause in your credit card agreement. I didn't read mine. I suspect you probably didn't read yours.
Well, I can't, my eyes actually can't deal with 4-point type, so it's almost impossible.
If you clicked on to certain sites on your computer, you've agreed to an arbitration clause. And increasingly, if you go to a hospital, you're going to be agreeing with those they ask you to sign. And you know, a lot of states have said, listen, that's unconscionable. The idea that you're forced to sign an arbitration clause when you're in the least position, you're the most vulnerable position of your life. And courts have said, no, it's preempted by the FAA.
So the suggestions that you've outlined, you're confident that those wouldn't be struck down if enacted because those would not be preempted?
I got to say, I'm not confident of anything in terms of predicting what this Supreme Court would do. I do think we ought to test the waters. The Supreme Court has said that the FAA is a strong statement by Congress that people who opt for arbitration should go to arbitration. Okay, well, let's give them fair arbitration. And let's say you're going to have to delineate, you're going to have to list the reasons for your opinion. You're going to have to make findings of fact. And your arbitrators are going to have to be impartial. And we're going to, by the way, the Attorney General is going to set up the list of arbitrators. What could the Supreme Court say? Well, that's just too fair. You know, we don't really want that. That's just too fair. I doubt they would say that. I think, you know, we're in a very fluid state here. We don't know what the court's going to be like in 3 years or 5 years. We don't know what, you know, this has been a very slim majority. We have even Justice Thomas saying that this is inappropriate. So it's hard to predict what would happen. But I don't think we should sit still idly.
I mean, they've already said that corporations are people, so who knows what they would say. Lee?
Thank you. I have a quick question. New York already has General Business Law, Section 399C, which prescribes mandatory arbitration consumer contracts, and given the recent Supreme Court holdings that you talk about, can you explain why the use of that statute is imperiled in New York? And I guess at least where one of the parties is interstate commerce, and perhaps touch on how loose, I guess, I would think the term of interstate, the finding of interstate commerce.
I think there's a real irony here because, as we can characterize them as the more conservative members of the Supreme Court, had started to cut back on the concept of interstate commerce as being an expansive overreach by the federal government until they got to the FAA. And then, of course, they completely changed course, and virtually anything is now in interstate commerce. Certainly any hospital, any nursing home, any website, anybody who buys goods in interstate commerce. The FAA has basically overtaken state arbitration law in virtually any context. Starbucks, you go into Starbucks if they have an arbitration clause. I don't know if they do, but that's interstate commerce, of course. So virtually everything is interstate commerce. And 399C, by the way, was argued in the Friedman case. The woman who went to the nursing home, didn't matter, preempted. 399C and 2801D of the public health law, preempted. In the Southland case, where the Supreme Court had a California statute that said any contract that limits in any way the franchisee's rights under state law is void, preempted, entirely preempted. So the reach, the combination of the interstate commerce and the Supreme Court's interpretation of the FAA has made the reach so expansive that virtually any attempt to substantively limit arbitration is a dead letter.
And you outlined, and we're going to hopefully work with you in the committee as the day goes on. We hear other comments from other individuals on some of the suggestions that you have put forth in terms of possible legislative solutions. And I guess that the real trick is, if we're looking at legislation, is to make sure that that we're not preempted by the federal government. We can't focus just on arbitration. We have to make changes to general contract law in New York in order to capture some of these changes. Is that
yes?
That true?
There's language in the FAA itself that says effectively, you know, you can't prohibit arbitration except under general contract. That would apply generally to contract principles. So that seems to be an invitation to state regulation of contracts in general. But the Supreme Court has even eviscerated that language because if they perceive any general statute of contractual applicability to be aimed at arbitration, they will strike it down. So it's hard to predict how a court would react to any particular provision, but I can guarantee you that any provision that directly points an arrow at arbitration will be struck down. A more general statute, for example, one of my suggestions is let's look at a bill that says in the healthcare area, people should not be subject to a private contract. The rights and duties of the patient, the doctor, the hospital should be determined by state law, case law. There should be it's not the legislature finds as a matter of public policy that it's not a situation where the parties should be negotiating because the parties do not have equal bargaining power. When you go to a doctor, you're going to a fiduciary. When you go to a hospital, you're not only going to a fiduciary, you're in a situation where you're not in a position to bargain effectively. And the legislature should say, no limitation on the rights of any individual in that context should be determined by private contract.
I do have
Assemblyman Steck.
thank you. Thank you, George, for your very fine comments. I have a question, and that relates to sort of, one thing I've learned in 30 years of practicing law is that conventional wisdom just sort of gets accepted, and then it's very hard to get past that. And one of in our own CPLR, we basically endorse the fact that arbitrators do not have to follow the law. Perhaps a simple change that might require them to follow the law might permit legal review of arbitration decisions. I find in doing research on how the courts treat arbitration, it's impossible to tell. It's almost an arbitration itself. The decisions are absolutely all over the place as to what the powers of the arbitrator are. Maybe we should focus on how you can challenge an arbitration decision after it's rendered.
I think that's an excellent point. What's lost in all these cases is a clear definition of what is arbitration, which really hasn't been addressed, I don't think, by all of this case law. And the question is, how far can you push the envelope to make arbitration more like a court in the sense of due process? And you have to follow the law, and you have to give a list of reasons, and you get some type of review that's greater than traditional arbitration. Again, in the context of 1925, what Congress was talking about was the traditional notion of arbitration, which is a private resolution where the arbitrator's decision is basically unreviewable, where the arbitrator does not have to give a statement of reasons. And I do want to emphasize that in the context of sophisticated business parties that negotiate at arm's length, they certainly should have the right to arbitrate. And our committee has been a strong proponent of alternative dispute resolution, and in particular, court-annexed arbitration. We have no problem with the parties doing that. We think JAMS is a great idea. We think it's a good organization, and we think that for those who voluntarily choose that process, it's a great process. This is not voluntary in any sense. So I agree with you that I think the area of most fruitful review is how can we make, if we're going to be stuck with arbitration, how can we make arbitration as fair as possible?
Okay.
Thank you very
much. Next is Catherine Tully, Director of Government Affairs of the Business Council of New York State. Good morning. Raise your hand. Do you swear that your testimony will be the truth?
Welcome.
Good morning.
It's been a while.
Good morning. Yes, it has. Thank you. Thank you, Chairman Dinowitz and Chairwoman Weinstein and members of the committees. My name is Kate Tully. I'm Director of Government Affairs at the Business Council. I thank you for this opportunity to present before the committee. I will not read my testimony, and I will just highlight essentially where we are, this issue applies to, obviously, to a number of our member committees. And what we have found in speaking with them is that this is an important tool that benefits both the consumers and that it does provide a fair and accessible means for resolving disputes. They can get it resolved quickly. It's efficient. They are not subject to going into court, having to deal with a court system that is, frankly, very overburdened as it is and underfunded and is difficult to navigate. This provides a way where you can get on the company website, you can file the form, and most of them make it very easy. It's effective. And in many businesses, they pay the costs of arbitration, and unless there's some kind of frivolous claim that may result in other things, but the consumer's costs are typically capped at about $200. And then, existing federal and case law ensures the fairness of the arbitration hearings. The federal law is there. The courts have concurred and are consistent with their decisions on that. I think that there are mechanisms in place. The American Bar Association has rules and policies that many companies do follow, and their protocol are in place, and that as a result, there is a system that provides, for the most part, consumers that are coming to court or coming to an arbitration with small claims, they can be taken care of. I think the numbers are small right now because a lot of companies take care of these matters on the consumer level. You call, you have an issue, most of them can be resolved right there. Businesses don't want to have to be drawn out into court, and spend millions of dollars trying to resolve very small claims when there is an alternative way to do it that's fast, that's efficient, and is working. And essentially, that is what I'd like to present at this point.
Well, that was certainly short and sweet.
Yes, well, after my esteemed colleague before me, I felt that he presented many cases, and I could say, well, I dispute many of them based on what I've seen talking with our members. So,
do you have any data on how often the consumer prevails in these disputes that are settled through arbitration?
There is some data out there, yes, and I think I referenced it in my testimony. Through the American Arbitration Association, there's a couple of reports, the SEAL Study Institute and others, that show that consumers can fare and do fare well in arbitration proceedings.
Okay, well, that's not data, but I guess we can do further research. But well, let me ask it a slightly different way.
Sorry.
Does data exist, or do you have data that would indicate for particular arbitrators how often they rule in favor of the consumer?
I do not have any data. I could do some research, but not in front. No,
I mean, that would be good information to have. I mean, while we cannot assume that the only fair outcome is if the consumers prevail half the time and lose half the time, if it turns out that it's 95-5, that certainly would raise some flags, as would if particular arbitrators ruled in favor of the business 95% of the time and the consumers 5% of the time. That certainly would also raise red flags, I would think.
Yes, but I know with our members, many of them utilize the American Arbitration Association's consumer protocol, which has in place standards of fairness to ensure that the consumers are given all opportunities in the process.
I'll just ask one or two more questions. How do consumers know that they're signing an arbitration clause? I mean, what efforts are made other than that microscopic font that we might see in a credit card application? I mean, honestly, until a few months ago, until I read the Times articles, I really didn't know I signed any arbitration clauses. And I'm a lawyer. I like to think I'm somewhat savvy. But my guess is virtually nobody would know they signed a clause. Is there any special effort that's made, given the fact that people are essentially out of court as a result of these clauses? Do you know of any special efforts that are ever made to make sure people know exactly what they're signing?
Well, I think that you and I, when we take our clicker and we agree to the terms and conditions in a contract, we have decided we're going to purchase this service, this good. It may have arbitration provisions, it may have many other things in there, but you are agreeing to it. It's a contract. It's a contract right there and then.
Well, I would think in a contract, both sides know what they're agreeing
Right,
to.
and it's my responsibility to read that contract.
And I'm not a clicker.
Yep, and I have actually taken the time to, prior to the Times article, prior to being told, hey, guess what you're doing next week, that I have read them, and I have seen that is the means. But at the same time, I do know that when I personally have had issues with various services, whatever, that you call up, and for the most part, 90% of the time, they're going to resolve it, and they're going to resolve it in the consumer's favor, because businesses don't want you out there bad-mouthing them. They need to work with the system as well. So it works both ways.